Thank you very much, Donald, and good morning. Well, let's get right to it. We have reached as Donald said, the 11th panel of this symposium. But if you think back to our first panel, where we had a top plaintiff's attorney, Nate Finch, and a top defense attorney, Mark Behrens, who we just again heard from, arbitration was a major issue they clashed on. Nate decried adhesion contracts that forced his clients into arbitration and kept them from their day in court. On the other hand, Mark, as the defense attorney, described arbitration and bankruptcy as where companies are able to manage the rush of cases coming at them. Now, this is our 15th symposium that the Judicial Education Program has held on civil justice issues. I believe I've been to every one of them, and arbitration, I believe, has been a constant subject at each one. So, to bring us up to speed on the latest in arbitration, we have a terrific panel this morning. And in the order that they're going to be presenting, first is Mary Donovan. Now, if you want a full biography of each one of these individuals, please refer to your booklet. But Mary is a principal at NDP Analytics, where she is also the senior economist. She has conducted a number of surveys in arbitration and what the public thinks about arbitration, and she's going to be sharing a lot of that data with us. Next on the panel, we have Arent Kaplinsky. He's senior counsel at Ballard, Spahr, LLP, where he was the practice leader of the firm's over 80 lawyers in the Consumer Finance Services Group. He writes a regular update on what is happening in arbitration. Third, we have Jim Copland, who is a senior fellow and director of legal policy at the Manhattan Institute. He focuses on the improvement of America's civil justice system. Fourth, we have Brian Farkas, who practices complex commercial litigation with Arent Fox LLP in New York. And he also has the best of both worlds because he also teaches arbitration at the Benjamin Cardozo School of Law. And finally, as our cleanup hitter, we have the Dean of the University of Georgia Law School with us here, Bo Rutledge. Bo is also the Herman E. Talmadge Chair of Law at the University of Georgia Law School. And as you know from our readings, Bo is extremely published in many publications on arbitration. And he also is the author of the seminal book, Arbitration and the Constitution. So, Mary, if you'll tell us about some of your findings.
Yeah, absolutely. I'm going to come up here. I have a few slides. All right. Well, thank you. Thank you for having me today. I feel like slightly a black sheep in this room of lawyers and judges. I'm an economist, but I am happy to share with you some of our most recent work. And taking an empirical look at arbitration and litigation allows us to kind of step back from a lot of the kind of emotional discussion that you see especially in DC where we're based, and have a little bit more of an objective look at it. So about 4 years ago, we were approached because the academic and third-party literature in this space was a little bit dated. And what you saw in the more recent analyses were that people were citing back to the same 2 or 3 empirical studies that were done in the early 2000s. And fortunately, we had the capabilities in-house and partners who had access to PACER records through Lex Machina, which is a big aggregator of data, that allowed us to build really big data sets and look uniquely at these two systems and how they serve both employees and consumers. So a little bit about our data sets. What I'm going to talk about today actually isn't survey data. It's data from the PACER records and the 2 biggest arbitration providers, which are AAA and JAMS. We were able to build 2 data sets, one for employment cases, one for consumer cases. And in each case, we have those federal court records and we have the arbitration records. They're both about over 100,000 cases in each database. So it's quite a big sample size. Oh, that's our first slide. All right. So let's move into the outcomes. When you look at the two venues, it's really interesting because at a high level, they're very similar. In the employment space, about 3/4 of both the arbitration and litigation cases are settled. And the remainder are kind of divided between cases that are dismissed and withdrawn and cases that are awarded, and we're calling them decided here. In the consumer space, it's not as parallel, but you still have that same story where the majority of cases are settled. And in arbitration, we have just under 60% being settled and just over 21% going to that award space. And in litigation, we have nearly all, 85% of those cases are settled and only 6% are awarded. But where a lot of the interest lies is within these awarded cases, these little blue bars on this side, what's going on in there? How often do employees and consumers actually win? So we calculated the win rates in each case for both consumer and employment litigation. And in arbitration, employees initiate and prevail in 32% of those decided cases. When you compare that against litigation, you have 11%. That's almost 3 times the difference. In the consumer space, it is a little bit more of a narrow difference, but you have 44% of the cases consumers initiate and prevail, and in litigation, it's about 30%. So there's a few notes here, and I'll get technical for a minute. But first off, you can see, first of all, the date ranges are different. That's because we conducted our employment research. It was published in 2019, and our consumer research was published in 2020. So we're talking about 2 different publications. But we looked at the most recent arbitration through June 2021, and we found similar results. And in fact, the arbitration win rates were slightly higher than they are here. And then the second technical note is that, you know, anything, when you're looking at a rate of anything, it's about what you divide it by. And I have a little asterisk here saying that we're looking at cases that are with one prevailing party. And the reason we want to talk about this is because you have your employees, you initiate, you prevail, that's great. In the arbitration data, there's a lot of instances of cases where it's flagged that both parties won. And for the purposes of our research, we consider that a wash, and we're only looking at cases where one party won, either the employee or the employer was the winner. But if you want to snap back, again, we took a look kind of like backhand, what would happen if you brought in that definition of the denominator, right? What if we're looking at all cases? Regardless of what you make the denominator, arbitration is always, in our analysis, more favorable than litigation when it comes to the win rates. So if you take the number of employee plaintiffs that win in litigation, you divide it by all the cases that were brought forth, you do the same thing for arbitration, it's going to be higher in arbitration. So again, we've narrowed down to those employee and consumer plaintiffs that win. The next question is, you know, what do those wins look like? And the question everybody asks is, how much do you make? And it's important to note here is that when we take out the class actions from the litigation database, the awards in arbitration are actually higher. When you leave the class actions in, the awards in litigation are higher. So for both employees and consumers, from the median, the mean, and the 90th percentile, the award rates are higher. And something that most people in here know, and I think is generally accepted, is that arbitration is also faster. But with our databases, we wanted to say how much faster is arbitration than litigation. So in these cases where the employees and the consumers brought forth the case and they won, it was determined about 100 days faster in arbitration than litigation in the employment space. When you look at the consumer space, it's about 130 days difference. So all in all, there's a lot of favorable data for arbitration indicating that consumers and employees do have a good shot of winning in those venues, that they do receive awards, monetary awards, and if they get to that point faster, which, as you can imagine, is good not only for the individual, but also for the business. So with that, I will hand it over to the next. I know there's a lot of data, but happy to discuss it when we open it up for that.
Thank you very much. Alan?
Sure. Good morning. I think I'm supposed to say your honors. Am I right? It's really a pleasure being invited to this this event. I think this is the first time in my entire career, and it's been a long one, that I've actually been able to address judges from on high, and not just looking at one, two, or three judge panel, but 150 or so judges. So thank you for giving me this thrill today. Let me just tell you very quickly about my practice. I'm a consumer financial services lawyer, have practiced for about 50 years, the last 25 or so at Ballard, Spahr, based out of Philadelphia, and I also work in Manhattan. And a lot of my focus during at least about half my career has been on the impact of consumer arbitration. And indeed, my interest in arbitration really stemmed several years ago from some horrendous litigation that I got enmeshed in some places which have often been referred to as judicial hellholes. I'm not going to mention any of those states because I'm sure some of those states may be represented here. But they were states where if you were defending a big bank or big financial institution, which is a lot of the work that I did in class action litigation, you really didn't have, you weren't working with the level playing field. And so my clients started asking me, have you got any thoughts or ideas that you can share with us? And that got me interested in arbitration. There was 25 years ago, even though the Federal Arbitration Act seemed to permit consumer arbitration at that time, and that was enacted back in the 1920s, it had really not been utilized very much. There was some experimentation within California with a couple of the big banks, but that's about it. Well, anyway, I got interested in the question of determining whether you could put into a consumer arbitration agreement contained in a consumer contract, like a credit card agreement, language prohibiting the parties from participating in a class action, either in court or in arbitration. We litigated that issue for at least a decade, maybe more. It ultimately went up to the U.S. Supreme Court, and in a very important case that the Supreme Court decided in 2011 called AT&T v. Concepcion, the Supreme Court held that the Federal Arbitration Act preempts or overrides any state law that would prohibit the use of a class action waiver in an arbitration agreement. However, that was not the end of the story. In 2010, Congress enacted the Dodd-Frank Act, and in that statute, they provided for the creation of a brand new federal agency called the Consumer Financial Protection Bureau, or the CFPB. And they required that the CFPB conduct a thorough study of consumer arbitration to determine whether it was fair or not to consumers, and if not, what they ought to do about it. Should they ban it by regulation? Should they regulate it in some fashion? Anyway, it took several years for the CFPB to conduct the study. It concluded the study in 2015. There were some 3 field hearings all over the country, and I was an industry representative at all 3 of them. And ultimately, they came out with a regulation deciding, they conducted a huge study. It was like 750 pages of print. And the ultimate result was not to ban individual arbitration. That was okay in their mind, but they banned or purported to ban the use of class action waivers. Then Congress got involved. And under the Congressional Review Act, which is a rather arcane statute that hadn't been utilized very much since it had been on the books, they adopted a resolution that got passed through the House, the Senate, and it was signed by President Trump, and it overrode that regulation. That was the end of that. Now, the topic that I've been asked to talk about is the economic impact of arbitration on consumers. I'm very, very interested in the study that Mary conducted, and I really want to dig into the details there because I think it could be very useful to those of us who are fighting the battle for consumer arbitration. What I am going to talk about in my brief remarks today is the data that the CFPB developed in its own study. They did this enormous study that looked at class action litigation. They looked at individual arbitration. And here are the highlights, and there are basically 3 takeaways. Number 1, the average arbitration lasts 2 to 7 months, while class litigation goes on for 2 or more years. Number 2, under the AAA's consumer arbitration rules, the consumer share of the arbitration costs is capped at $200, and often by contract, and in a lot of the contracts I've drafted over the years, the company agrees to pay 100% of the costs of arbitration, including the arbitration filing fee and the other ancillary fees charged by the administrator, the cost of paying the fee of the arbitrator himself or herself. That's half the $200 fee, which is charged when the company doesn't agree to pay the whole thing, is half of the $400 it costs to just file a complaint in federal court. And my guess is that, I haven't done a survey of all the state court filing fees, but my guess is they are probably more than $200, or it's at least comparable to $200. But you don't have to pay for the judge, and there generally aren't additional filing fees. Consumers, and this is really the salient point, consumers recover far more in arbitration than in class action litigation. Consumers who prevailed in an individual arbitration recovered an average of $5,389. In contrast to that, consumers in class action settlements got a paltry $32.35 on average. But class action counsel did quite well in the cases that were studied. They recovered a staggering almost $425 million. Not so good for their clients, but very good for themselves. The impact of arbitration on companies, again, I'm just going to look to the CFPB study. And the CFPB study makes it clear, and I'm looking at the, looking for the actual figure. There would have been, if this arbitration rule had not been repealed by Congress, there would have been They estimated over 6,000 class actions would have been added to the already overstressed state and federal court system, and it would have cost the industry billions and billions of dollars. Also, final point I want to make is the impact on federal and state court dockets. Arbitration, I believe, has the effect of making your lives a little bit easier. I know you're already overburdened and overwhelmed with handling cases. Class action cases take up an inordinate amount of time. They're very complicated. They go on for such a long period of time. The effect of what I've been advocating is to reduce that burden on the courts. So with that, I'm going to conclude, and I know we're going to take some questions a little bit later. Thank you again very much.
Thank you, Alan. Jim?
Thank you, Alan, and thanks to George Mason Law and Economics Center for having me. I guess I'm a bit more of a regular than our first two presenters here. I guess it's the third one I've done in the last 13 months or so. It's nice to see a full room. When I was in Savannah last fall, everyone was sort of really spread out, masked, remote, and then when we did one in March, I'd had one shot. I guess the vaccines were just getting rolled out. I think some of our audience had had more, but very complicated stuff with mailing in PCR tests and rapid tests every day and this sort of thing. So it's good to see a little bit of return to normalcy here. I direct legal policy at the Manhattan Institute for Policy Research, which means that, like Mary, I'm not really a real lawyer. I just play one on TV. I am educated in the law, but not really, because I went to Yale. So other than what I learned for the now late Ralph Winter as a clerk, most of my law is therefore self-taught. But I want to give a little bit of a broad perspective here. I mean, Mary's absolutely right. I mean, there's been a dearth of good sort of quantitative research here. So I resemble her remark. I mean, I've been writing about this subject for some years, and I keep pointing back to these old studies on this. So it's good to have some new stuff coming out there. I've been integrally involved in the CFPB rulemaking that Alan talked about. I criticized it in the Wall Street Journal. I did a comment letter to the CFPB, and then I argued for Congress to step in on the Congressional Review Act to reverse that rulemaking. So it's something that's near and dear to my heart on this subject matter. I mean, stepping back from this, at first glance, this is true. I was a few weeks ago on a Supreme Court preview panel for Federalist Society on this, and at that point there was one FAA, Federal Arbitration Act case on the October term docket. Now there's a second. They're relatively narrow questions, not as applicable for most of the folks in this audience, but this continues to be a big issue, and it's a little strange when you think about it. There's this 1925 statute, largely designed to sort of cabin the ability of labor unions to sort of sue businesses that came through here. And we've got this relatively modern jurisprudence on the Federal Arbitration Act, which is a function of both textualist methodology. We're not worried about what they intended to do with this 1925 law. We're worried about what it says on its face. But also I do think, and this is sort of the Yale legal realist in me coming through, I do think there's a bit of leaning into this, as my friend Michael Grieva, now at George Mason, formerly at AEI, has said, our litigation system's a mess, and this sort of opt-out provision through contractual arbitration is a way around that. And so while this is sort of an old relic in the law, that's true of a lot of the other things in our law too, right? I mean, the merger of law and equity, the creation of modern discovery rules, the creation of notice pleading that happened in 1938 is also sort of old, also sort of constructed and predated, was coterminous with the elimination of federal common law. So a lot of these state-federal questions that come into play in arbitration cases were coterminous with Erie v. Tompkins. Before then, you had a federal common law as a backdrop there. 7 years before international shoe. So while the Supreme Court in Erie was looking at vertical, looking quite expressly at sort of vertical forum shopping, wasn't thinking about the horizontal forum shopping that would later emerge that drives our litigation. All of this, of course, was decades before the creation of the modern opt-out class action device, which was written by two law professors on a ferry going to Martha's Vineyard as part of the Rules Enabling Act that empowered them via the Supreme Court to rejigger the federal rules, and then another decade more before the onset of modern sort of mass tort litigation. So these sorts of questions I think are important, and I think when we look at arbitration and class action, which is the real thing that the CFPB focused on, and really where a lot of the friction resolves here, we're not so worried about big businesses deciding to use an alternate forum in arbitrating, right? We're worried about these form contracts. We've all gotten them. We've all signed up for cell phones like AT&T Mobility. We've all signed up for financial contracts. They're embedded in there. There's not a negotiation. Are these really contracts of adhesion? And the sorts of questions that we've asked in this really relate to that. So I want to sort of briefly summarize the 3 points here that come into play that I sort of highlighted for the CFPB in my comment letter. The first of these, I think it's important to compare apples to apples here. It's also important to look at the procedural adhesion that exists inherently in the opt-out class action context, right? I mean, notice it isn't really that great there, right? I mean, I get them in the mail. I get emails telling me I'm a member of this class. You are precluded from further litigation through this too. So it's an important sort of backdrop. And the protective shield here doesn't really work very well. So my friend and former colleague Ted Frank, who founded the Class Action Fairness Institute or something like that, is now under the Hamilton Lincoln Law Institute, but he's basically a nonprofit professional objector to bad class action settlements. And he wrote a paper for us a couple of years after AT&T Mobility v. Concepcion, basically coterminous with Amex v. Italian Colors, the follow-on case in 2013, entitled Class Actions, Arbitration, and Consumer Rights, and really focused on these sort of structural deficiencies in our class action process. So every sort of critique you want to make about, oh, this is a contract of adhesion, blah, 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 true to some degree. You're not, really going through all this verbiage as a consumer. Also true of the opt-out class action. And we go through in that paper, and I document somewhat in my CFPB comment, the quote, undercompensation and self-dealing that's so severe that class settlements unambiguously harm class members by putting them in a worse position than they were before the litigation began. And you can see this, and these are the sorts of examples, I've been doing this a while, that we highlighted for the Congress in forming the intellectual framework for the Class Action Fairness Act of 2005. And so it's just an important thing to keep in mind. The second sort of point here is what I call inverse federalism, or in the book I published last year, The Unelected, I call sort of reverse or new anti-federalism that can come into play here, because you've got this state-federal interplay. And this really was sort of the animating principle of the Class Action Fairness Act. I mean, we were showing how you could get one state effectively overriding other states' preferences through national class action litigation, right? I mean, this is what was happening. Illinois was saying, oh, well, we have to have this rule on original equipment manufacturer auto parts through insurance, and overriding Massachusetts' choice in the exact opposite direction through class action litigation, which is why it was pretty easy to convince even Barack Obama, Hillary Clinton, a very broad cross-section of folks in the Congress that, we needed to make a procedural shift here. That's not the sort of rule that makes a lot of sense. That can be endemic here as well. So if California, as was the case in some of the consumer finance litigation and class action that sort of was a forerunner to the CFPB notice and comment rulemaking under Dodd-Frank, they were effectively changing the way banks ran and offered services to customers. And this started to go up as the CFPB started its rulemaking comment period. And so this is sort of the third point I made, it's important to understand, from a policy matter, and again, that's not going to drive what you do, I don't think, if you're doing your job the right way, but it's important to understand as a policy matter that there can be significant unintended side effects of the decision-making going on here when you're overriding these sorts of arbitration clauses and having this sort of top-down, one-size-fits-all rule that sounds good in a class action settlement. And so, I focused on the 30% of unbanked Americans in that comment letter and talked about how low-income individuals were getting more unbanked by the elimination of various late fees and things like this, which are really the only way profitably that banks above certain minimum cash thresholds. I mean, normally, yeah, you lose your fees if you have enough cash in the bank. A lot of people can't afford to do that. And so we were really worried about pulling people out of access to banking and consumer finance and credit and things like that. So just some of the thoughts, some of the broader context. We've got some folks that are going to go through some of the new developments and preemption and legislatively, and then finally the dean with some new, interesting new studies and work on this area. Thanks.
Thank you, Jim. Brian?
Hi, everyone. It's an honor to be here today. This is my very first Law and Economic Center event, so compared to Jim, I'm a relative newbie here. So I practice commercial litigation at Arent Fox in New York City, and then my fun job, my extracurricular fun job, is teaching arbitration law at Cardozo in New York. And I have class tonight at 8 o'clock, if my flight gets me back on time. If it doesn't, the students will be very happy, but it probably will. So I'm excited for class for two reasons. One of those reasons is that both Alan Kaplinsky and Rutledge are on my syllabus, so I'm going to take a selfie with them and convince my students that I have cool friends. So that's number one. The second reason I'm excited for class is that this is kind of a big week and a big month in arbitration law. There are currently hearings that actually just happened yesterday in the House, in the Judiciary Committee a couple weeks ago, in the Education and Labor Committee, on a really important piece of legislation that could totally change this conversation that we're having on this panel. So I'll get to that shortly, but those are the two reasons I'm excited for class tonight. So I'm going to focus on employment arbitration a little bit more. And our last couple speakers have focused really heavily on consumer arbitration, so I'm going to talk a bit on the other side of this, employment arbitration. So the context for my comments is really the Me Too movement, which, of course, it feels like a million years ago, right? Because it was right before the pandemic, but it really didn't peak all that long ago. This is 2017, 18, 19. The long and short of it is that a whole bunch of accusations came out against really several dozen really powerful men across law, media, other corners of society, finance. And what happened in many of those cases was that those men were accused, and it was generally men, were accused of something on the range of, at one end of the spectrum, sexual harassment in the workplace, on the other end of the spectrum, outright assault or worse. So in that context, many of those men lost their jobs, and there were questions that emerged among policymakers, among employers. How is it that all these guys kept their positions for as long as they did? And there are a lot of answers to that question. Some are cultural, some are economic, some are social. But many of the folks who were implicated in that were people who had been on the scene of American society for decades. Bill O'Reilly, Matt Lauer, Charlie Rose, people who were household names. So how is it that many of these claims that were made against them really didn't see the light of day in the media for so long? And one of the answers to that, I'm not saying it's the only answer, but one of the answers that was offered was employment arbitration and these mandatory clauses in employment agreements that essentially forced victims to not file public lawsuits, or if they did file public lawsuits, that they were then quickly ushered into arbitration through a motion to compel. So in that context, many state leaders were hearing from their constituents. You may remember the Women's March on Washington and other similar marches around the country. There was a large movement in the 2017, 18, 19 era to push state legislators to really think about how can we address this issue in the workplace. And one of the answers to that was to create state statutes to essentially prohibit the mandatory arbitration of sexual harassment and/or sexual assault. What does that mean? Well, it means to essentially remove those types of disputes from the general category of stuff that can be forced into arbitration. So there were actually 6 states that did this, and it was, I have it written down here so I wouldn't forget, California, New Jersey, New York, Tennessee, Vermont, and Washington State. There are 5 other states that are considering similar legislation. Now, all of that legislation, basically, it's slightly different in each jurisdiction, but the nutshell version of what that legislation does is it's usually an amendment to the state civil procedure code. So this is the state level civil procedure code, and basically what it says is we generally will follow the Federal Arbitration Act and will generally enforce agreements to arbitrate, except if the claims raised by the plaintiff involve sexual allegations of sexual harassment or discrimination, something like that. New York's, I think, is the broadest. Vermont's, I think, is the narrowest. But generally, that's the tenor of it. So, okay, sounds like it maybe makes some sense. What's the problem? Well, as Jim was saying just moments ago, they are running up into this wall of the Federal Arbitration Act, which is this 1925 statute, Section 2 of which says, and this is the big quote that everyone always cites with arbitration agreements shall be valid, irrevocable, and enforceable. And that is a quote that is often used in motions to compel, valid, irrevocable, and enforceable. And as other speakers have said, the Supreme Court has consistently determined that that language means that, well, valid, irrevocable, and enforceable. You can't come up with state legislation to escape that congressional command. You can't carve out certain types of disputes that can't be arbitrated. That's generally the consensus. So, well, now we have a problem because we have all these pieces of state legislation that are trying to do just that are trying to carve out this type of employment claim. And this, by the way, is nothing new. States have been trying to come up with little ways to regulate arbitration since the 1980s. And there was a very famous case called Southland versus Keating. We don't have to go into all the facts unless you're curious, but basically California tried to regulate the relationship between franchisors and franchisees. They said you can't arbitrate disputes in that context. The Supreme Court struck it down. And Chief Justice Warren Burger, who wrote that opinion, had this famous line in there that said, Congress, through the FAA, has enacted a national policy favoring arbitration, which is another line that is often quoted in motions to compel arbitration, even though it's not actually in the statute of the FAA. But that line has really stuck out to folks trying to get into arbitration. So anyway, what's happening? Well, it's exactly as you would expect. All of these state statutes, these 6 states that have passed this Me Too era legislation, are one by one federal court challenges preempting or casting doubt on that new state legislation. In New York, for example, where I'm from, there have been, I think, 4 district court cases out of the Southern District of New York and 1 out of the Northern District of New York that have all essentially said, we don't really know about this. This kind of feels like it's preempted. The Second Circuit hasn't yet ruled on it, but it feels as if it's coming, and my guess would be that in the next 3 to 4 months or so, the Second Circuit will probably hear one of those cases. And it will most likely be fall by the wayside. So that's sort of the context for this Me Too era legislation. The last thing I want to offer a comment on is, well, what could happen? Now we have all of these attempts, which, by the way, were quite popular in the states where they were passed, that are going to one by one probably be struck down, and we'll see that red flag on Westlaw bleeding down the legislation. So what's going to come next? So there are two ways that I see that potential change could occur here, because right now we're in this sort of logjam where states pass legislation, gets struck down by the federal courts. What could happen? Well, two things. One is that the Supreme Court could change its interpretation of the FAA. I know, not super likely. Judges don't often like to reconsider. But here's why that could be possible. Justice Thomas has dissented from basically every arbitration preemption case since he joined the Supreme Court. And his attitude is really a states' rights attitude. States should be able to govern contract law within their own borders, period. And he doesn't subscribe to what was decided in that Southland case that I mentioned earlier. He thinks that that was wrongly decided. Justice Scalia thought the same thing. And he wasn't quite as forceful about it as Justice Thomas, but he was pretty forceful about it. And here's why I think that's important. Justice Barrett just joined the court. She was, of course, his law clerk, Justice Scalia's law clerk. So I do foresee a potential situation, and this is total speculation, where we could have a Barrett-Thomas effort to sort of change or recontour the very expansive way that the Supreme Court has interpreted the Federal Arbitration Act. So that's one path. Seems a little unlikely, I know. Second path is what I mentioned at the outset of my comments, which is this legislation that's being considered by Congress, which it's called the FAIR Act, which stands for the Forced Arbitration Injustice Repeal Act. Leave it to Congress to come up with a good, juicy name. So the FAIR Act, as I said, there have been now 2 congressional hearings on it just in the last month. I think that the House likely could pass it under the current majority. Basically what that law would do, and this is a very Cliff Notes version, is that it would create an exception to the valid, irrevocable, and enforceable FAA language to ban sexual harassment and sexual assault claims from arbitration, or at least rather make those agreements voidable. So that's the FAIR Act. It probably could pass the House. The Senate seems somewhat less likely. So the nutshell version of my comments is there are 2 potential avenues to get around this conflict that now is emerging between the states on the one hand and the controlling FAA interpretation on the other. Both of those avenues not really seeming super likely. But I'm excited to hear what your questions and reactions are, and to what my fellow panelists have to say. Thank you for your time.
Thank you, Brian, and now we'll hear from Bo.
Thank you, Judge, and thank you, judges. Whenever I talk to a group of judges, and I have to say after the last 18 months, it's really nice to be able to do so. My thoughts drift back to 2005, which was career day at our then 3-year-old's preschool. And career day was not about deciding then and there what your child was going to become, but it was rather an exercise about public speaking and introduction and circle time. And it happened to come on the heels of a childcare crisis where I had a lecture the preceding day, and my then 3-year-old was sort of playing in the corner. So career day went as follows. My name is Bo. This is my dad. My dad's a judge. Well, Bo, what does a judge do? Well, a judge decides the most important things in a person's life. And my name is Molly. This is my mom. What does your mom do? Mom's a doctor. What does a doctor do? A doctor saves people's lives. So it rolls around to my 3-year-old. It's my dad. What does he do? He's a law professor. True story. What does a law professor do? A law professor talks all the time and asks lots of questions and never answers them. And so chastened as we all are by our children, my promise is to talk for exactly 8 minutes, not simply ask questions, hopefully answer some in these remarks, and gladly answer whatever ones you may have as they come into the chat. I do feel it would be helpful to sort of lay my priors onto the table, because unlike a lot of the former speakers, I actually came to arbitration through a different route. My career began actually overseas, performing and working in international arbitration disputes. I was based in Vienna, Austria, not long after the Berlin Wall fell, and was working over a host of disputes that arose following both European integration and the recession that sort of gripped the world right at the turn of the millennium. And what I sort of discerned from that was sort of the essential lesson that's always informed how I teach arbitration, both foreign and domestic, and that's this: that at the end of the day, the flow of commerce depends on a credible, effective mechanism for resolving disputes. That whether it is a US investor choosing to invest in a former communist country, whether it is diamond merchants in New York at the time of the American Revolution, or whether it is all of us purchasing cell phones, getting credit cards, renting cars, having our cable subscriptions, the availability of those commercial transactions, whether cross-border or across the street, depends in part on that efficacious form of dispute resolution that creates the conditions under which that kind of transaction can occur. And that is as true in the international setting as it is in the domestic setting. So having sort of laid those priors on the table, what are the 2 points that I hope you take away from my remarks? Point 1, beware, and Mary's slides are a perfect illustration of this, beware untested or unproven assertions about a system of dispute resolution. And number 2, to sort of bring back my international arbitration origins, recognizing that, with apologies to my former law school classmate, Judge Nielsen, and to Judge Donald, who many years ago came and gave a wonderful address at our law school, for the vast majority of you who are in state courts, recognize that just because an arbitration is international does not mean that state law is irrelevant. Let me unpack both of those for you. Number 1, sort of beware the untested empirical proposition. So you've heard from several of my panelists already about both the arc of arbitration, I'm talking domestic arbitration now generally, from 1925 through a period of the non-arbitrability doctrine, its eventual demise in the 70s, 80s, and ultimately early 90s, giving rise to this sort of expansion of domestic arbitration, including federal statutory claims, that brought to this sort of crescendo moment with the Concepcion case that tested whether or not Section 2 of the Federal Arbitration Act preempted a state law that, under the guise of a state unconscionability doctrine, precluded class action waivers in arbitration clauses. And as is often the case, whether one is litigating about arbitration or something else, the briefs and the testimony around this issue was filled with sort of, kind of bombastic assertions about the prevalence of arbitration clauses since the demise of the non-arbitrability doctrine, or the parade of horribles that would follow when the Supreme Court were to declare that Section 2 preempted the Federal Arbitration Act. And so much like Mary, a fellow professor, Chris Hosel at the University of Kansas, and I began to really sort of test empirically whether or not either some of these more exaggerated claims about the pervasive use of arbitration clauses was true, or whether the parade of horribles occurred. So let's start with the pervasiveness argument. Now, one of the tricky things here, of course, is that how does one actually sort of test whether or not arbitration clauses are used, whether comprehensively in a particular industry, because it's not like one can simply go to the library and sort of check out arbitration clauses in the Dewey Decimal System and find the answer. You have to sort of dig. And so we began with credit card filings, because credit card filings were required by the Federal Reserve to be put on file. They were publicly accessible. And so we began with sort of the first order question, which is how pervasive are these arbitration agreements in fact? This is discussed in one of the footnotes in the paper that was assigned. And what we found, interestingly, was notwithstanding these sort of exaggerated assertions about the pervasive use of arbitration agreements, that at least as to the credit card industry, they weren't actually that widely used, that the vast majority of banks didn't actually include arbitration clauses in their credit card agreements. So there's an important qualifier to this that I'll come to in a few moments. Then Concepcion occurs. And so the second thing we wanted to test was whether or not the parade of horribles would follow. Would, on the heels of Concepcion, this sort of tsunami of arbitration clauses come and follow? There we sought to test it by reference, if you've had a chance to do that reading from the paper that was included, franchise agreements, where we really sort of looked over the arc of time as opposed to the snapshot. Was the use of arbitration clauses in franchise or franchisee contracts radically affected by the Concepcion decision? Here we were looking, again, kind of fishing in the lake at franchise agreements, because many states required those franchise agreements to be sort of deposited with the Secretary of State. So we had sort of a stable database that we could sort of scrape to test that. And again, we found no, that in the wake of Concepcion, that there was not this sort of, herd of activity toward spiking the use of arbitration clauses, notwithstanding the parade of horribles that sort of pervaded the briefs, as well as pervaded the testimony around parallel legislative reform that was being considered, antecedents to some of the things that Brian and others talked about. So that was sort of the state of the world when Chris and I wrote both the paper that you all have been provided, as well as the paper in the Journal of Empirical Legal Studies that sort of referred therein. And what's been interesting is that in the time that has followed the publication of that paper, as the availability of big data, the ability to sort of scrape and mine data to do the kinds of things that Mary's doing every day, that basic idea that contractual behavior is actually a lot stickier than the sort of the chicken littles of this debate would lead you to believe, continues to be the case. So a 2021 study in the University of Chicago Law Review found that across a study of SEC filings, whether ESOPs or executive compensation agreements. 2019 study of the gig economy found that. Another 2019 study of 100 different contracts across 6 industries found that. And perhaps most curiously, or most interestingly, and I really sort of have to say it was really refreshing when the CFPB report that Alan and Jim and others talked about came out, that there was sort of honestly a degree of honesty about it, that notwithstanding sort of the chicken little argument, that in, for example, the banking industry in the heels of Concepcion, that there had not been this massive rush to changing behavior. Now, 2 important qualifiers. How do I avoid overstating my claim about overstatement? Number 1, that this is very industry specific. So, for example, in contrast to the financial services industry, we do see a spike in the use of arbitration clauses, for example, in cell phone contracts. And so one has to be careful in generalizing. Number 2 is a recognition that even within a particular industry, one needs to sort of unpack. So going back to what I said earlier about the financial services industry, it is true that across industry participants, the rate of utilization of arbitration clauses was quite low. But if one looked at it not in terms of the number of participants, but the share of the market controlled by participants, in certain industries, the vast majority, say, of the credit card debt held in the country is under an arbitration clause, because there are a small number of players that are controlling that credit card debt and do in fact use arbitration clauses. I'll sort of, in the interest of time, put a pin in the international arbitration point. Again, for those of you who are state judges, just because it's international doesn't mean state law doesn't apply. I'll gladly answer it in the Q&A. To the extent I haven't answered your questions here, I look forward to them. Thank you very much.
Thank you very much, Bo. Bo, I'm really surprised that you used SEC in your remarks, but it wasn't in the normal context that I think of with the University of Georgia. And I'm surprised that you made your remarks without referring to the #1 team in the land.
I'm engaging a certain amount of expressive conduct with the math. So.
Okay, we have a number of good questions. One of our top questions is, if arbitration is so good for consumers, why do corporations work so hard to enforce it?
The cost savings, right?
Yeah. When I, during my remarks, I focused on class action litigation. And, you know, in the interest of full transparency, a lot of the motivation of companies is to deflect or mitigate the risk of class action litigation. Under Concepcion, the Supreme Court opinion, that's now generally doable because you can override or preempt state law. So companies are looking at what does it cost them to manage class action litigation? What do they ultimately have to pay out? In many instances, the settlements are, bear no relationship to the merits of the case. In order to get rid of class action lawsuits, you can very often get rid of them by paying the named plaintiff a relatively small amount, but paying the attorney $50,000, $75,000 for essentially doing no work other than drafting what could be just a copycat complaint. And very few cases, class actions actually go to trial. It's just that they soak up a lot of money and a lot of effort over a long period of time. If you weigh that with the cost of setting up a system to manage individual arbitrations, the cost-benefit analysis almost always comes out in favor of arbitration.
Yeah, I mean, I think one important point here, yeah, clearly any business that's running itself, run by fiduciaries, is going to be trying to be profit maximizing, right? I mean, that's why businesses are doing this. But there's a lot of money left on the table here because of the way our system works. You know, just as, you know, a business is going to incur a cost either way, right? A business will incur a cost either way. Now the question is, why would you want individual arbitration as a business, even outside the class action context, right? I mean, because theoretically, because we have a one-way, because we have a non-fee shifting system, unlike the rest of the developed world, you know, that would probably deter a lot of consumers from seeking compensation absent an arbitration clause. But customer retention and customer feedback wind up being pretty important when you're talking particularly about the industries where we see, and it is very sector industry specific, as Dean Rutledge said, but particularly on these industries, it's very important. I mean, cell phone companies advertise incredibly aggressively to try to acquire new customers. Banks also advertise pretty aggressively. Credit card companies advertise pretty aggressively trying to acquire new customers. So why do they do that? Because each customer is valuable. And arbitration is a relatively low-cost way to resolve customer disputes. It gives an instant feedback loop mechanism to the company about what's going on. And it's a way to retain customers. I mean, and let's be clear, I mean, customers that are valuable. There may be customers where you're losing money on the customer and you don't care about losing them. But by and large, that's not true. It's certainly not true in the cell phone context, which is why the actual arbitration clause that Andy Pincus, my friend at Merrill Brown, like sketched out that AT&T Mobility used in the AT&T Mobility v. Concepcion case was so consumer friendly. I mean, AT&T Mobility doesn't want to lose customers. They do want to allow customers to be able to complain. And some cases, they want to be able to compensate them. What they don't want to do is go through a litigation process because the transaction costs of that are way higher and it's very inefficient and there's just no way they'll do that. So I think even outside the class action context, It's valuable for companies, depending, again, on the industry or depending on what we're talking about. But the class action thing, obviously, is a really big one.
Well, you anticipated one of the questions we had here. One of the judges wanted to know, outside of the class action context, why would they do that? And so I think you kind of
yeah, I think that's right. I mean, listen, each is going to be different. I mean, employment is going to be quite different, as Brian's talking about. Now, listen, there can be a Mott and Bailey game going on here as well, right? I mean, when I would say that the sexual assault and harassment state laws, while they may be preempted by the FAA, probably are. They're somewhat superfluous, right? I mean, we saw this game going on 15 years ago when the Democrats took over the Congress in a wave election in 2006. The last Democrat senator seated, former SNL writer and comedian Al Franken, comes in, puts on the agenda. First thing he introduces is an arbitration-related reform in the employment law context. Pulls out a young woman named Jamie Lee Jones, who alleged that she was gang raped by folks working for Halliburton over in Iraq, and puts her in front of the Senate, et cetera, et cetera, et cetera. Well, I mean, long story short, I mean, the Fifth Circuit ultimately determines, no, this arbitration clause is out for this sort of case, right? So even as a matter of federal law, some of these cases, these state law exceptions aren't necessarily going to matter. Now, she ended up losing her case when she went to court, and it's an interesting tale. If you want to see it, Google Stephanie Mensimer's account on this in Mother Jones. As you would infer, Mother Jones isn't a particularly big business friendly outlet. Stephanie Mensimer wrote a book against tort reform. We disagree on everything, but when she looked at this case, the case actually sort of fell apart on the facts. But regardless of that, I mean, the Fifth Circuit put that case in court. But what Franken was doing was using that case, an outlier, an extreme fact pattern, and then trying to eliminate a lot of other arbitration in the employment context where it might make a lot more sense.
Does anybody have any?
Just want to add one thing. When it comes to individual arbitration, the calculus can vary from client to client depending upon the size of the individual claims that you're talking about. If you're talking about a credit card company, generally the individual claims are pretty small. I got charged a late fee and I shouldn't have been charged a late fee. Or there was some other debit to my account, or the bank failed to credit my account in a certain way. It's probably better for those kinds of cases to go to court, because the industry is going to have more leverage in court than in arbitration. But let me just mention what I consider to be, from a policy perspective, what I think is a failing in our country. And there are a lot of people to blame for it. And that is that a lot of consumers don't realize that they've got arbitration provisions in various agreements that they're subject to, and that they do have leverage over companies. If they can't get something resolved through customer service, there is very often an ability to go over arbitration where the company pays all the fees. And in that AT&T mobility contract that in the Concepcion case, there's actually an opportunity to get, if you win, if you don't accept the last offer made by AT&T and you prevail in arbitration, you get some multiple of what your actual damages are. So there's a lot of incentive to do that, but the problem is nobody is educating consumers. The CFPB, I've said it all along, I said it to Richard Cordray when I was testifying at one of their hearings. How can you spend so much time figuring out how to regulate arbitration? Why don't you spend time trying to educate, putting money into educating consumers about dispute resolution and how arbitration really compares to litigation? You haven't spent a nickel on that, and you've spent millions of dollars on other things. And of course, he didn't have an answer for that. That's where I think the federal agencies have fallen down, the state agencies. That's where I think even industry has to do a better job in educating consumers.
Alan, we just had a question come in from one of the judges asking why credit card companies don't arbitrate minor default cases, because those really clog up a lot of our dockets.
Yeah, the answer is that those kinds of cases, nobody is going to handle those kinds of cases. AAA isn't going to handle them. JAMS isn't going to handle them. There used to be a company called the National Arbitration Forum that thought that they would make a business out of handling collection cases. And they got involved in it big time. But there was a hue and a cry. A lot of people were very upset about it. They got involved in some very ugly litigation. It's a long story, but to make a long story short, the National Arbitration Forum, it didn't take very long before they went out of business. So there really isn't any way right now for collection cases to be arbitrated. That's not to say that a company couldn't come along and develop a fair way of handling those cases, because I know that certainly many of you, or if not you, your fellow judges in your courts are deluged with default cases. And in most cases, there's no defense to the default. 99% of the cases, it's just that the consumer can't pay for whatever reason or doesn't want to pay. So there is a need there for it, but right now nobody's filling that need.
Okay, we have lots of great questions here, and we need to make sure we kind of give a little shorter answers so we can get to more of them. Mary, there were a lot of questions that came in with regards to some of your findings, and one of the questions that some of the judges had was about were there geographic differences in the answers that you were getting?
We didn't analyze the data by geography. The AAA and JAMS data do have state information, but the federal court data is a little bit limited in where those cases actually started from. So we didn't analyze that. I think it is an opportunity to keep the answer short.
Sure. Okay. And also, one of the other things that some of the judges wanted to know about was there a difference in your findings between agreed upon arbitration and mandatory arbitration?
That's another area. We didn't differentiate between mandatory and non-mandatory arbitration.
Okay. One of the questions, and because I just opened this up to everyone on the panel, has mandatory arbitration contributed to a decline of the jury system? What do you think?
The jury system, most cases settled to begin with. Right. Most criminal cases plead to begin with. And in class action litigation, which is the alternative to a lot of these big ticket disputes, they're almost never go in front of a jury. So I'm not sure it's all that germane, right? I mean, listen, most of these arbitration cases, when we're talking about consumer or smaller dollar tickets, I mean, they would never get in front of a jury. Nobody's going to touch them. There's not enough money at stake. That's why companies are going to drop these. Right?
Bo, did you have any thoughts on that?
I agree with that. There's a relatively famous article by Owen Fiss called "The Vanishing American Trial," and I think from a causal perspective, there are a lot of forces that have effectively kind of precipitated the decline of the jury as the effective decision maker in most civil disputes. I've never believed that arbitration is really kind of radically adding to that phenomenon. No.
Another question, are there any studies on the procedural justice aspects of arbitration?
Yes, there are many of them. I think that to Mary's point earlier, many of them are not all that heavily informed by data. It's a lot of dispute resolution theory on theories of justice, which is actually the title of one of the articles, Theories of Justice, by a scholar named Leela Love. There are many articles that sort of talk about the perception that individual citizens have of the court system, the judiciary, and how that's impacted if they're then forced out of that system effectively by arbitration. But I think, again, to Mary's point, there's often not a lot of data to support what we may think that citizens believe about those different mechanisms.
Okay. Any other panelists have any thoughts? Another question, after American Express versus Italian Colors, what's left of the defenses to arbitration?
So I guess I would say there are probably four, in my estimation, that are spots where the rubber continues to meet the road. I think number one, which interestingly is grabbing an increasing amount of attention at the intermediate, federal, and Supreme Court, is the issue of waiver. So, if one unpacks the Section 2 analysis for a second, the Section 2 analysis says that arbitration agreements shall be valid and enforceable save upon such grounds as exist at law and equity for the revocation of any contract. And that has been read to include the generally applicable contract defense of waiver. So there is a good bit of litigation over whether or not a party's pre-arbitration conduct amounted to waiver. I would say number two are sort of scope questions, sort of going back to what one of my fellow panelists said, that just because there's an arbitration clause in a contract doesn't mean that it covers everything under the sun. Number three, periodically you bump into just kind of one-sided, goofy, written in a different era arbitration clauses. And number four, sort of picking up on something that Brian said, I agree with Brian's second point that one area where you could continue to see some defenses to the enforceability of arbitration clauses are little legislative carve-outs. And so even in the heels of Italian Colors, it is, I think about Italian Colors essentially as a separation of powers decision. Are you going to let courts, or are you going to let the lawmakers decide what types of claims can and can't be in arbitration? And it is worth recalling that even under federal law today, certain disputes between automobile manufacturers and their dealers, certain disputes between poultry farmers and wholesalers, certain disputes involving defense contractors, and certain disputes involving residential mortgage agreements, all as a matter of federal law cannot be subject to pre-dispute arbitration as a result of federal law. So it's not as if the federal lawmaking process is sort of broken. The question becomes, how is one going to sort of go about regulating the cost-benefit analysis of overriding a contractual choice? And I do think that in the current political climate, it would not be surprising in light of some of the hearings that Brian has talked about if you continue to see these sort of crossover coalition efforts to sort of carve out the enforceability of arbitration clauses in certain niche industries that Republican senators don't want to hear from their constituents when all of a sudden they're in an arbitration.
Yes. Let me just add one additional hot issue, particularly in California, and that is the California Supreme Court in a case called McGill v. Citibank held a few years ago, 2-3 years ago, that a claim, an individual claim seeking public injunctive relief was not subject to, governed by the Concepcion case. They concluded that was a carve-out as a matter of law. That issue awaits Supreme Court, U.S. Supreme Court adjudication. My hope is we have a case in front of the Supreme Court right now from California, and my hope is they will grant cert. But of course, you never know what the Supreme Court is going to do.
Okay, do we have any, we're just about at the end of our time. Does any of the panelists have any concluding remarks they'd like to make? Bo?
No, I guess the only thing that I wanted to sort of throw out there that I thought was really interesting from Mary's data, I hadn't seen that data before, and the conventional narrative about win rates in arbitration was that the win rates actually were less that prior to your data, win rates were more company friendly. And the argument was that if one simply focused on win rates, it overlooked sort of the settlement effects, that a sensible company, whether in arbitration or litigation, would not let a case go to decision if there were bad facts. And so I was sort of curious if you have explored or hypothesized why the win rates that you are seeing, given your much more robust data set than the earlier literature, kind of, in my opinion, they sort of give lie to the historical settlement effects explanation for the win rates in the earlier empirical research.
So there's one thing, when everybody talks about settlements, and the big question is what happens in that settlement, right? Because it makes up such a large portion of all cases. Unfortunately, there's no data on settlements. So I don't have an answer on whether or not you're better off settling or not settling in either venue. But a lot of the prior research, it's the win rates are, it's all about the definition, right? So when we're looking specifically at the employee plaintiffs and whether or not they win their cases, and dividing it by the number of decided cases in both venues, because we believe that's an apples to apples comparison, we see better win rates in arbitration. In a lot of the literature, if you go and you read the fine lines, there's different ways to calculate those win rates. Yeah. And sometimes they're not comparing apples to apples. And I think that's what we found in a lot of the work that we've looked at that's been done in the past.
That makes sense.
Okay, well, thank you very much, and please thank our panelists.